Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is actually a license law tip, and it's quite an interesting question. So the question is, if there are two agents on the same team working in one transaction, in other words, one team, and they have a listing, and then the team also gets a buyer who wants to buy that property and also wants to be a client. Is it a dual agency situation or a designated agency situation? Interesting question, don't you think? So I thought so. So let's go into this a little bit and back up, but stay tuned to the end for the answer to this question. So let's talk just briefly about a quick way to understand agency. And I'm going to back into all this with the laws and with some citations for you. But basically speaking, a public person becomes a client of a broker by virtue of signing a brokerage agreement. And that is required. So in Georgia, the client relationship is created contractually, and it is created contractually when the client signs a brokerage agreement. And the law that states that is our what we lovingly refer to as our BRRETA laws. And BRRETA stands for Brokerage Relationships, the Brokerage Relationships in Real Estate Transaction Act. And it is in our Georgia law books. It is Title 10, Chapter 6A, under Commerce and Trade, Brokerage Relationships in the Real Estate Transaction. And it is state law that basically says it prohibits a broker from representing the seller or the buyer, a public person, as a client without first entering into a written agreement under the BRRETA laws. And again, OCGA 10-6A-1. So the client relationship is created contractually in writing. Now, what else does BRRETA go on to say? Well, before I get into BRRETA, let me back up and let's talk about agency, single agency, dual agency, and designated agency. So if a public person has signed a brokerage agreement, either a seller brokerage agreement or a buyer's brokerage agreement, they are now a client of the broker. And you, the affiliated licensee, are affiliated with the broker. So even though you talk about them as being your client, they are actually the broker's client. So if a public person has not signed a brokerage agreement, then they are a customer of the broker. So single agency is when the broker represents one party in a transaction as a client. So you can have seller agency or buyer agency. Designated agency is one broker, two agents. Each agent has a client relationship with their party. So you've got one broker, and the broker has two agents. One agent has signed a listing agreement or seller brokerage agreement with the seller. The other agent has signed a buyer brokerage agreement with the buyer. One broker, two agents, each with a client relationship with their parties. If that is in the same transaction, then that is a designated agency situation. And the easy way to think of it, again, all affiliated licensees are affiliated with the broker. All contracts are in the name of the broker. So the easy way to think of it, and where this name came about, is the broker has designated agent A to work with the seller and designated agent B to work with the buyer. Now, we know in practice, the public, the agents end up working with the public. It's not that the public comes to the broker and the broker actually assigns them. But that's where the term came from. And you have to remember, real estate's been around for a long, long time. But anyway, designated agency, one broker, two agents. Each agent has a client relationship with the principal, one with the buyer, one with the seller in the same transaction. That's a designated agency situation. Now, what is a dual agency situation? A dual agency situation is one broker, one agent, and that agent has a client relationship with both the seller and the buyer. That is dual agency. Now, just parenthetically, an agent may have both sides of a transaction without it being a dual agency situation. If it's one broker, one agent, and that agent has a client relationship with just one of the parties, then that agent has both sides. For example, let's say the agent signs a seller brokerage agreement. You have the property listed. You get a sign call that buyer wants to buy that property. If you do not sign a buyer brokerage with that buyer, then the buyer is a customer. So that can be one agent having both sides of a transaction without it being dual agency. Is it legal? Yes. However, you need to check with your broker's policies whether or not your broker will allow it. And I encourage you to treat that the same way you would treat a dual agency situation, even though it's not technically dual agency, with disclosure and consent, and offering the buyer another agent should they wish actual agency representation. But back to the topic at hand. So let's look just a little bit more about dual agency versus designated agency. Because again, the question is, if you've got a team and the team takes a listing, they signed a seller brokerage agreement, so the team has an agency relationship with the seller, and then they get a buyer and they sign a buyer brokerage agreement with that buyer, and then it turns out one of the listings the team has is perfect for that buyer. So the team, agents working on the team, have an agency relationship, a client relationship with both the seller and the buyer. If they come together in one transaction, what is it? Is it designated or is it dual? That's the question at hand. Well, let's look a little bit further about BRRETA and the laws. So is dual agency, first of all, is dual agency legal? Well, it absolutely is legal with a couple of caveats. And those caveats are, it is legal as long as there is written disclosure and written consent. And there's a lot of laws that govern all of these issues. There are GREC laws, there are license laws, there are agency laws in Georgia in general, and there is the BRRETA laws. So, GREC Rule 520-1.02 defines agency, means a relationship in which a real estate broker acts for or represents another by the latter's express authority in real property transaction. Dual agent means a broker who simultaneously has a brokerage relationship with both seller and buyer in the same real estate transaction. So we've already covered that. Then there are, under GREC Rule 520-1-.06, under brokerage relationships, it first of all says that each exclusive brokerage agreement must be fully set forth its terms and have a definite expiration date. And going on, it says a licensee shall provide written disclosure to both buyer and seller, revealing the party for whom that firm is acting and from whom that firm will receive valuable consideration for its efforts as an agent in the transaction. Additionally, the written disclosure requires that these disclosures be made timely, but in any event, not later than the time that any party makes an offer. Now, the BRRETA laws further define or explain or go on to characterize more of what is required. Again, BRRETA is a Georgia law that governs the agency relationships of both brokers, buyers, working with buyers and sellers. And it imposes legal duties or a standard of care upon an agent, how to interact with the public. There's duties an agent owes a client and duties an agent owes a customer. You guys have all heard the term fiduciary. someone who acts for the benefit of another in a relationship founded on trust and confidence. That's the definition of fiduciary. So under the BRRETA laws, duties to a client is to perform per the signed brokerage agreement, promote that client's interests, exercise ordinary skill and care, comply with all laws and regulations, and keep information confidential. However, that confidentiality only goes to the extent of anything that a broker is required to disclose by law. In other words, you are charged under agency laws to keep confidences, but there are other laws that also impose a duty upon you, for example, to disclose latent material defects. Even if your client says, shh, don't tell, you have a bigger duty to law per your license to disclose latent material defects. And that does not violate the confidentiality laws under BRRETA, to which you must adhere. Now, you must give a written agency disclosure to the buyer and the seller that describes representation, compensation, as well as the types of agency offered by the buyer. So don't worry, you do not have to write all of this out if you are using either a GAR, Georgia Association of Realtors contract, or an RE Forms contract. Now, if you are a party to another contract, a new construction contract, a HUD contract, Fannie Mae, Freddie Mac, attorney written contract, some of these disclosures, these agency disclosures may not be in there. So you need to make sure that you are in compliance with Georgia license laws regarding disclosure of agency relationships, as well as a host of other things like firm number and your license number. Again, if you are a party to a contract other than the Georgia Association of Realtors contract or the RE Forms contract, which some people refer to as the FMLS contracts. But in, for example, the GAR contract, it is disclosed in the actual purchase and sale agreement, which for GAR, this is in the RE Forms too, but in GAR, it is Form F201, and there is a section where where the parties consent to dual agency or not, but it is further described under paragraph B10. I think it's B. Yes, B10. And that goes on to describe the brokerage relationships in this transaction. It describes what that it does disclose the agency relationship, or if there's no agency relationship, and it does describe what dual agency is and have a consent for dual agency. It further goes on to describe what designated agency is and gives a consent for designated agency. Additionally, this disclosure is also in the seller brokerage agreement and in the buyer brokerage agreement. There is a disclosure regarding the agency relationships that a broker offers or does not offer. And if dual agency is one of the types of agency that a broker does offer, it does have a place where the buyer or the seller, that party does or does not consent to the broker acting in the capacity as dual agent. So it is completely disclosed, again, if you are using a Georgia Association of Realtors contract forms or the Georgia RE contract forms. So now, question at hand. What about a team situation? In a team situation, in that scenario, team has secured a listing and they get a buyer. They sign a buyer brokerage agreement. So the team is working with the seller as a client, buyer as a client. That property is perfect for that buyer. Dual agency or designated agency? What do you think? Little bit tricky. So if it is a team in which there is one agent that is representing the seller, or not representing, because the team, this is part of the answer, I guess. Generally speaking, a lot of times on a team, there will be one member of the team that works with on the seller side of the team, and one member of the team that works on the buyer side of the team, or more than one. But usually there are team members that specialize more on the listing side versus the buyer side. So the answer is, number one, check with your broker and make sure of what your broker's policies are regarding this type of situation. And if, regardless of any laws, your broker needs to consent to these this type of agency situation, especially in a team setting. So the question comes down to, well, you are looking out for your clients. Well, actually, I don't know if I went over this, but basically more on BRRETA laws is that I did cover this. You do have a duty to the principal and to the client. Now, hopefully, the duties, the best interest of a buyer and the best interest of a seller are the same to secure the property, for one to sell and one to buy. Sometimes there could be a few bumps in the road where the ultimate goal is the same, but the methodology or the terms under which the parties achieve that might be a little bit different. So, is in a team situation, if the team acts as a team and the contracts are signed by the team, the way the team operates is there are team meetings and all the team members understand these are team listings, these are team buyers, and there is information shared in team meetings, whether it be verbally or on paper, or if there is a team administrator, if there is a team leader who has knowledge of both sides. If it truly is within the team situation, and the contract, a lot of ways you can tell this for sure is if the contracts are signed in a team name, then regardless of the actual agent interacting with the public person, with the public seller and the public buyer, if it still is team, then that really would be a dual agency situation, because even though there might be individual agents acting on behalf, there they are, acting on behalf of the public buyer and the seller, within the context of the contract, it is still one entity, that team entity. So that would be a dual agent situation. If the team members within the team truly are working at the individual interest of the party and not within a team setting, then it would be a designated agency situation. So it is a bit tricky. If, again, bottom line is check with your broker. If contracts are all signed in a team name, listing agreement in a team name, for example, team name by such and such agent, buyer brokerage team name by such and such agent on that team, then that really is a dual agency situation, even though you might have individual team members interacting with the public. Bit tricky, regardless if it is a dual agency situation, a designated agency situation, or an agent or a team having both sides of a transaction where you only have an agency relationship with one of the parties. One example I gave is the team having a listing, signing a listing, seller brokerage agreement, having it listed, getting a sign call, and working with the buyer. Buyer wants to buy it. Another way is you have a buyer that you've signed a buyer brokerage agreement with, and you go buy, for example, a for sale by owner. That, again, you can have both sides of a transaction without it necessarily being a dual agent or a designated agency situation. Check with your broker. Even if you have both sides, best rule of thumb is disclose, get consent, and let the parties understand what is going on. If you are in that situation and one of the public parties does choose to have their own representation, whether it is you're acting as with one as a customer, both as clients, both as customers, all public people are entitled to representation. But representation and compensation are two completely separate issues. So if you are in the middle of the deal and the contract has been done, and then one of the parties says, you know what? I think I really want my own agent to look out for my best interest. That is fine. You cannot prevent them from getting an agent even after the contract is done. If they're your customer, you cannot prevent them from getting an agent and signing a brokerage agreement with another broker or with another agent within your company. But compensation to that other broker is going to be handled between the party that desires that agency relationship and the broker whom they hire to represent them, because the contract's already done. There's no obligation at that point for a seller or a listing broker to compensate a broker that is brought in, but you cannot deny a party representation. So again, representation and compensation are two separate issues. Whew, a lot there. There is a lot more on agency. I could do a whole 3-hour class on agency. Perhaps I will, but just wanted to tackle this issue regarding license law and give you a couple of tips about where you can find this information in your contracts. Thank you guys so much for watching. Dana Sparks, Nami, and Sema. Hey girls, say hi. Broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.